The C-SPAN networks bring you long-form public affairs programming from the nation's capital and are a public service of your television provider. C-SPAN, created by cable.
Well, it was in 2010 that the Federal Communications Commission issued and approved an open internet order prohibiting broadband providers from discriminating against internet content. Here's former chairman of the FCC, Julius Genachowski, talking about that open internet order.
Today we're adopting a set of high-level rules of the road that strikes the right balance between these imperatives. We're adopting a framework that will increase certainty for businesses, investors, and entrepreneurs. In key respects, the interests of edge innovators, the entrepreneurs creating internet content services and applications, their interests, the interests of broadband providers, and of American consumers are aligned. Innovation at the edge catalyzes consumer demand for broadband. Consumer demand spurs private investment and innovation in faster broadband networks, and faster networks sparks ever cooler innovation at the edge. I believe our action today will foster an ongoing cycle of massive investment, innovation, and consumer demand, both at the edge and in the core of broadband networks. Our action will strengthen the internet job creation engine. Our action will advance our goal of having America's broadband networks be the freest and the fastest in the world.
And that open internet order was the topic of a court case heard this week in D.C., Verizon versus the FCC. Former Republican Commissioner Robert McDowell, who was the top Republican on the commission in 2010, joins us by phone. Commissioner McDowell, what was the argument that was heard at the commission about this open internet order?
Well, first of all, Peter, thank you for having me. And this is a very important topic, and you're covering it at a very good time. The court arguments earlier this week went on for 2 hours, even though the original schedule, I think, was about 45 minutes. So that shows you just how interested the judges were in the subject matter at hand. And it's complex. It's complex legally. It's complex factually. And one of my concerns is that here we had a room full of lawyers. I am a lawyer, so I can say that. And are they determining the fate of how the Internet should evolve? And that could be a little disheartening when up till now we've had the Internet grow and prosper and blossom because of engineers and academics and user groups and the free market. So what's really at the heart of the court case is whether or not the FCC had the legal authority to do what it did. And there are lots of different legal theories there, different layers of the statutes. But a threshold question for me back in 2010 is what is broken in the marketplace that the FCC was trying to fix. The FCC did not do a bona fide or peer-reviewed market study of the broadband market before leaping, and I think that was a mistake. So first of all, nothing was broken to be fixed, and second of all, I didn't think the FCC had the legal authority to do what it did. Having said all that, I'll conclude this part by saying there are plenty of other laws on the books that will protect consumers. There's no dispute, at least for me, that the Internet should be open and freedom-enhancing and a permissionless place for all of us to improve our lives in an unfettered way. But there are antitrust laws and consumer protection laws and the potential for class action lawsuits should Internet service providers ever discriminate in an anti-competitive way that harms consumers. So I think there are plenty of laws in the books, but if not, then Congress needs to address this, and the FCC just can't legislate the way it tried to do.
Commissioner McDowell, how long did the FCC grapple with this issue of net neutrality?
A long time, actually. Even going back to the early days of the Bush administration, when FCC chairman at the time, Michael Powell, came out with his Internet Freedoms statement, because academically or in theory, people could see or contemplate whether or not there would be an economic incentive for Internet service providers to discriminate in an anti-competitive way against content or applications. I think, though, as we've seen, first of all, more competition in broadband and the higher use in wireless broadband, which is the fastest growing segment of the broadband market, and the mobile screen is quickly becoming the first screen for consumers. I think that we have a new market, a new era here, and that those concerns really hold up the way they did 10 years ago.
And that was Robert McDowell, former Republican commissioner on the FCC. Thanks for joining us on the Communicators. And now joining us at our table here at C-SPAN is Randolph May, who is president of the Free State Foundation, and Gigi Sohn, president and CEO of a group called Public Knowledge. Ms. Sohn, first of all, what is Public Knowledge's involvement and position with regard to the Verizon versus FCC case?
So Public Knowledge is a nonprofit advocacy organization that represents the rights of Internet users and the desire of Internet users to have an open, unfettered Internet that is not controlled by gatekeepers like the cable and telephone companies that provide Internet access to the world, the Internet that we've come to love, the one that drives economic growth, free speech, democracy, innovation, creativity. We were interveners on the side of the Federal Communications Commission in this case. So we were supporting the FCC's determination that there was a concern with these bottleneck companies controlling who are the winners and losers on the Internet, and that they had the right, both the legal authority and the authority under the First Amendment and elsewhere in the Communications Act, to protect consumers and protect competition by prohibiting these gatekeepers from favoring certain content, services, and applications over others.
And Randy May, same question, Free State's position and involvement in this case.
Well, Peter, thanks for having me, first of all, and Gigi and I are longtime friends, and even though we disagree a lot, we always enjoy discussing these issues. The Free State Foundation is a nonprofit educational and research institution as well. We're nonpartisan. We're a free market-oriented organization. We primarily focus on communications policy and Internet issues. We do a few other issues as well, but that's our primary focus. And I've been involved in the net neutrality issue since the very beginning. As Commissioner McDowell said, that goes back a long way. So our position has been that to oppose the adoption of net neutrality rules on both policy and legal grounds. I think, as Commissioner McDowell said, and this is a very important point just in terms of the policy issue, there was really no evidence, and the Commission itself didn't make any findings that the Internet providers actually have market power. Gigi already several times has referred to their bottleneck, but that's really inconsistent with the Commission's own findings or lack of findings regarding their market powers. So I really start from the proposition as well, if there's not a market failure and if consumers aren't being harmed, if there's no demonstrable evidence of consumer harm, then there's no reason for the Commission to regulate in an anticipatory fashion. Now, as to the legal question, I think the Commission lacks legal authority. I think we also were interveners in this case, and we argued that the Commission's rule even violates the First Amendment. But aside from that, I think the court will hold, and this has been my position all along, that the FCC doesn't have the authority to regulate these Internet providers essentially as common carriers, and that's what the Commission's rule actually does. And I think that the court's decision will turn largely on the fact that what the FCC has done is say, we're going to regulate you just as we regulated common carriers back in the old monopoly telephone era.
So there's good news and bad news about what happened on Monday. So let's talk about the good news. To the extent that the Verizon in this case, and people like Randy and Commissioner McDowell said that Congress never gave the Federal Communications Commission, the FCC, the power to regulate broadband internet access, there didn't seem to be much question among the judges that they did have that authority, that they did have that power. So that's good news, because if they were to rule otherwise, and I just want to make the caveat that you can never tell 100% from an oral argument in a court what the ultimate outcome is going to be.
And I'll agree with that caveat right up front as well.
But it appeared, and I was in the courtroom, it appeared that the judges basically took as a given that the FCC had the authority to adopt these rules under a particular provision of the Communications Act. So that's the good news, because that question doesn't just go to whether they can adopt net neutrality rules. It also goes to whether the FCC could stop fraudulent billing of broadband providers, whether they can protect the privacy of consumers of broadband, whether they can promote universal access to broadband among all Americans. So it really was a core question of, will the FCC be relevant at all when it comes to the communication system of the 21st century? So that's the good, again, assuming that the oral argument foreshadows what's to come. What's not so good is what Randy was talking about, that two of the judges, Judge Tatel and Judge Silberman, seemed to be very concerned. They didn't seem to be very concerned. They were very concerned that the FCC, by prohibiting this discrimination against edge providers, was treating internet access providers, broadband internet access providers, like telephone companies, like common carriers. So under the law, common carriers have to serve everybody indiscriminately. They cannot discriminate in their rates, in their conditions, and their terms. And the judges felt that this is exactly what the net neutrality rules did. And the Communications Act says point blank, you cannot treat non-common carriers like common carriers. And the FCC has classified broadband internet access providers as common carriers. Now let me tell you why I think the judges shouldn't go with their concerns and why they should allow, let me just finish this one point. Why they should not find that these regulations are common carriers. For two reasons. Is number one, a common carrier relationship is formed when an internet access provider has a customer, all right? So under the net neutrality rules, let's say I'm Verizon and you're a Verizon customer. I can refuse to serve you. Okay, I can absolutely just say, Peter, I don't want to serve you, or I'm going to charge you more than I charge Randy. But that's not what the net neutrality rules do, okay? There is no customer relationship between the edge provider and my internet access provider. And what the net neutrality rules do is say, internet access provider of Gigi's, you cannot charge the edge provider twice. You cannot charge them twice for coming to Gigi. So there's no relationship between the edge provider and the internet access provider in that case. Now, it's very complicated. So let me make the easier point. The easier point, and this court, in fact, Judge Tatel has said it himself, is that when it comes to determining what is a common carrier and what is not, the expert agency should get deference from the court. And that's what was so shocking about the oral argument. You had two judges telling the FCC general counsel, no, this is not how common carriage works. This is how it works. And that is in flat contradiction to its precedent, and it's in flat contradiction to common sense, because you ought to let the expert agency determine what common carriage is and what it isn't.
Randy May.
Well, look, there's a lot to unpack there, and I'm happy that Gigi found some good news in this oral argument, because most people walked away from the oral argument, myself included, thinking, and again, I'll add the caveat that you never can be sure, but thinking that the FCC is going to suffer probably an important defeat here. And here's the reason why. Gigi asserts that it seems like there's not a question that the court will say the FCC has some authority over broadband internet providers. And that's probably true. I think they might well do that, but I think the more important point is that this net neutrality regulation that the Commission adopted under Chairman Janikowski was really the FCC's central effort to exercise that regulatory authority over broadband providers. Sure, there's some other things it may do, like enforce transparency rules with regard to internet providers. But the whole thrust of this regulation, as Gigi alluded to, was to prevent discrimination. That's really at the heart of it. But the reality is that it's that discrimination prohibition that in effect converts the internet providers into common carriers, I think, as Gigi recognized, or at least as she recognizes that the court seems to believe, and as I believe. And so if the court writes a decision which strikes the anti-discrimination part of the rule, which most observers took to be the central part of the Commission's rule, it's really eviscerated as a practical matter, apart from sort of parsing theoretically what might remain as a legal matter. It's eviscerated a good part of the Commission's authority. I mean, it's one thing to say the Commission has some authority, but if the most important thing the Commission was trying to do is held unlawful, then, from my point of view, that's the good news, really, there. Now, let me just say, and I think this will introduce another part of the conversation, a good part of the argument during the court argument had to do with whether the FCC's rule, which the FCC said prohibited internet providers from charging what are referred to as edge providers, those are the content providers, the Googles and Facebooks and whatever, charging them a price for reaching their customers or sending traffic to the broadband provider, whether in fact that was illegal. And the court, whether the FCC could prohibit that. And I think it's pretty clear that the court's going to say that part of the rule is unlawful and strike that down. And I think from the point of view of the internet providers and what they say they want to do and what Verizon said it wanted to do at the oral argument, that rule against so-called two-sided pricing is probably at the heart of what this whole battle is really about, and I think Gigi may well agree with that.
Yeah, I definitely do agree with that, and I also agree with Randy to the extent that it will be somewhat of a Pyrrhic victory for our side if the FCC lands up having authority, but that they can't actually exercise that authority in the most meaningful way possible. I mean, Verizon's counsel, who is fantastic and a friend of mine, Helgi Walker, she basically said Verizon wants to force edge providers to pay a second toll in order to get priority service or better quality of service. So that's what they want to do, and that fundamentally changes what the internet looks like. And if I could address what Commissioner McDowell talked about, is antitrust can solve all, because this is the new, well, it's not such a new meme, but it's been the meme of the last couple of years of the telephone and cable companies. In fact, the Washington Post had a story about it today. We don't need the FCC to deal with broadband. Let the FTC do it. Let the antitrust authorities do it. Let me make a couple points in that regard. Number one is when it comes to antitrust, consumers, and this is unfortunately because of Supreme Court precedent, consumers don't have a lot of rights and ability to bring antitrust cases, okay? It's all about the competition. So maybe a Google, which by the way could pay for the priority, could bring an antitrust lawsuit, but consumers are very, very constrained. And antitrust law is very constrained. It doesn't get to basic consumer harms. And let me give you the ideal example of where antitrust law would not apply. So in the Kevin Martin era, the George Bush FCC era, his FCC found that Comcast was blocking BitTorrent peer-to-peer traffic for no good reason, okay? and found it illegal. And that led to a court case where the FCC was not found to have authority, but that's what I'm talking about. That kind of case would not be one where antitrust would reach it, because it was not a competitive issue. Okay, it was just an issue where they felt that BitTorrent was full of pirated movies, was a bandwidth hog, and so they just blocked it. So that's the ideal case, and a case which could come up again and again and again. And by the way, getting back to the evidence, the FCC did have evidence that internet access providers were favoring or blocking or discriminating. There weren't a lot of them, but there were a handful of them. But it was still evidence, and an agency like the FCC has the right to make predictive judgments. Those are the kind of judgments that courts are supposed to defer to. So antitrust law really is not a strong enough tool, and the FTC, the Federal Trade Commission in particular, the laws that it operates under, would not get to a lot of the concerns that organizations like mine care a lot about.
At this point, I don't even want to address frontally whether the FCC should have absolutely no jurisdiction over broadband providers going forward, or whether, as Gigi says, some people want all of that should be over in the antitrust realm. It may be that ultimately that's where it should be in my view, but let's put that aside for a moment. A fundamental problem with this whole proceeding, and I think a difference between Gigi and I is, certainly myself and the FCC, despite pointing to, I think, 4 isolated incidents that could be characterized as potential net neutrality violations or incidents had the rules been in place, there really wasn't evidence of any widespread or even non-widespread consumer harm. And a problem with the way and that's a fundamental problem with the way the FCC approached this case, because it didn't say, in fact, in paragraph 78 of its order, it explicitly acknowledged that these rules would be put in place regardless of whether any of the ISPs had market power, regardless of whether it made any market power findings. This goes to Judge Silberman's conversation that he had. Right in paragraph 78, it said these net neutrality rules are good in and of itself because we believe in openness. Okay, now that sounds good. Openness, per se, sounds attractive, and it makes a nice slogan. And the fact is, right now, the internet, and I think we all would agree, is basically open. But the other side of that is, and the problem with the way the FCC approached it, when you put in place a regulation that has the flat prohibition against discrimination, again, which was the core of the FCC's regulation, you have to recognize that there may be cost to that, and there may be trade-offs. Now, we can even talk about balancing the benefits of openness against the cost, but you have to recognize that. And the cost can be real, and they can go to the deterrents to new business models, to innovation, and to the willingness to invest. If the broadband provider believes that the only thing that it can offer is going to be just like the next broadband provider. But the FCC really didn't wrestle with it at all with its trade-offs, because it said openness is good in and of it itself. So you have to be willing to acknowledge that there's some trade-offs, and you have to understand, regardless of how you balance them, that they could be a deterrence to innovation and investment.
So I have 2 points about this. Number one, I think the FCC did recognize it. You heard what former Chairman Janikowski, what he just said. He said, when edge providers thrive, and that's good for the network, and that's good for the consumer. So you have this sort of virtuous cycle, of the growth in these apps and the content and the services, and that helps that makes consumers want to buy internet access. Okay, makes the Comcast and the Verizons, the AT&Ts of the world very, very wealthy. Comcast has 97% profit margins. That's the second point. So these rules have been in place since the beginning of 2011. Not only has the world not fallen apart for the internet access providers, they're investing more. AT&T announced a little while ago is going to invest $21 billion in its broadband. So these companies are not suffering, and they can do innovative business models. There's just one business model they can't do, and that's one that picks winners and losers over the internet. So it's not the FCC saying you can't innovate, you can't do new things. The FCC is not saying you can't even have your own content. If Verizon wants to have its own content, Comcast obviously has its own content and owns NBC and a bunch of other channels. But they're saying in this one place, you can't have that two-sided market, that double toll on the edge providers. And they have thrived.
And we are almost out of time. Very quickly, Randy May, when and what will be the decision by the Court of Appeals?
Well, predicting when is very difficult, but my guess would be it would be 3 or 4 months would be my best guess. And I believe that the FCC is going to suffer a defeat that will be meaningful in the sense that it will, I believe, eviscerate the core of the net neutrality rule, which was this anti-discrimination provision. There may be something left of the FCC's authority, but I think the FCC will suffer defeat. And then let me just add that I hope then that if that's the case, the FCC will not rush to try and reinitiate another proceeding to put in place net neutrality rules again, but it will just engage in watchful waiting and see what happens in the marketplace.
So if the oral argument is any indication, the FCC's authority to regulate broadband to protect consumers and promote competition with regard to broadband internet access will be preserved. The anti-discrimination rule, part of the rule, will probably be sent back to the FCC, and I fully expect the FCC to try again to make sure that it doesn't have the indicia of common carriage that the court may be concerned about. The anti-blocking rule, which says that an internet access provider cannot plain off block edge providers, will probably be maintained. But I do hope and I do pray that there was one judge we didn't talk about, Judge Rogers, who is likely to uphold the FCC's jurisdiction and also the rules as and defer to the FCC on their determination of what is common carriage. I'm hoping that she can convince Judge Tatel to go with her on the deference question.
And it may come as no surprise to anyone, but our two guests are lawyers. Gigi Sohn got her law degree at the University of Pennsylvania. Randy May got his law degree at Duke. This has been The Communicators on C-SPAN.